client and your vendor contracts. First point here is limitation of liability clauses. You'll see this a lot with your vendors. I have seen a number of times in 2026 already, a client or a prospective new client comes into my office and they say, I've got a breach of contract with my vendor. It cost me a ton of lost revenue. Let's go after them. Let's sue them. Let's get everything back. And then when you dig into the contract, you see that there are very specific clauses that protect the vendor for things like consequential damages, punitive damages, lost profits, and so on and so forth. Next, payment terms. Just because you haven't received a complaint from a vendor or a customer about payment terms doesn't mean that you're doing things right. You need to evaluate the payment terms in each contract that you've signed and make sure that those are scheduled and properly handled internally so that you don't end up with any errors in billing your clients, but also you don't miss any payments timely to your vendors. Next thing is IP and deliverable ownership. Maybe sometimes the ownership of these things passes to your client. It's important that your agreement with your client properly spells out what the deal is. So a handful of annual review questions to ask. Let's look at our vendor agreements. Is there any potential risk there? If they shut down our business or if there's any significant interruption of business, are we able to recover for that? Do we need to plan a backup? Do we need to find a new vendor? The same thing with clients. We need to make sure that the agreements that we have signed with our clients are good for our current business model and that they protect us from unnecessary risk. If they don't, maybe we need to amend those agreements with our clients.